Our final speaker is James Lawford Davies. He's a partner in Hill Dickinson's health team. Have I got it right? And honorary lecturer at University College London's Department of Biochemical Engineering. James.
Thank you, Allan. Thank you, Sarah, for the invitation to speak. And it's great to be here. It's great to see so many people turn up to this very important event and to hear a lawyer talk about an incredibly esoteric, specific area of regulation. So it's reassuring. I'm going to talk about two areas and two different issues, but related issues. I'm going to talk again about the regulations, although there will be some overlap with what Rachel's already said, but I'm coming at it from a slightly different perspective. And then I'm going to talk about some of the judicial remedies that may be available in certain circumstances where there are regulatory problems and hurdles that clinics need to overcome. I'm aware that it's a very diverse audience, so I'm going to try not to talk too much about the real specifics of the regulations, but hopefully it will be of general interest and applicability. We love to regulate in the UK. It's a beautiful irony of leaving the EU to escape red tape that we invented red tape. And we are a global superpower in the use of red tape, and leaving the EU certainly won't change that. Health is an area that we love to regulate particularly tightly, and IVF has not escaped the attention of lawmakers and regulators. Far from it. It's a very, very tightly regulated area of medicine. And the storage of embryos and gametes is regulated in its own right. You might be excused for thinking that the focus of regulation would be on the use of embryos and gametes. But in fact, there are a number of provisions in law in the UK which relate specifically to storage. One of those is the prohibition of the storage of embryos and gametes by anyone that doesn't have a license from the HFEA. It's rare, but some centres and clinics in the UK have storage-only licenses, which permits them to store. And without a license from the HFEA, you store illegally. If I started storing sperm samples at home in my freezer in an ice cube tray, I would require a license from the HFEA for the storage, even if I'm only using it for gin. It's a statutory requirement that you hold a license to store, even if you're not intending to use it in treatment. It's also a condition of every storage license that is granted by the HFEA that they are kept only for this statutory storage period that Rachel's already mentioned. Now, this is the first point that I'm going to mention, which is inherently confusing. For gametes, it has always been 10 years, that initial maximum storage period. For embryos, it started off as 5 years and was later extended to 10 years. But it is now 10 years for both embryos and gametes, and you can't store for longer than that unless you satisfy these medical requirements, which we'll come on to look at. And thirdly, as Rachel has already mentioned, you have to have consent. You have to have valid and effective consent to storage. And the Act also sets out what you need to do in order to take valid consent from patients for that to comply with the statutory requirements. All of these considerations were tested in what is now quite an old case, but still a very important case, brought by Diane Blood, who wanted to use sperm samples taken from her late husband, who had not completed any HFEA consent forms at all. And the court considered the licensing status of the clinic where they were stored, but crucially, the lack of consent, and found that those samples could not be used or stored legally in the UK. Despite recognizing and not doubting Mrs. Blood's intention to have a family and her expressed intention on the part of her husband for her to have a family after his death. The court was also very clear in stating that it would be a criminal offence for the clinic to continue to store or to use those sperm samples in the UK. This is not the choice of the clinic, and it's certainly not the choice of the HFEA. It's a matter of law in the UK that clinics simply cannot store beyond the statutory storage period. The only narrow exception is this question of medical extension, which both Melanie and Rachel have touched on before. These, at the moment, are embodied in the 2009 statutory storage regulations. The regulations apply to both gametes and embryos, and in relation to embryos, you are permitted to store for beyond 10 years, where both gamete providers have provided their written consent to the extension, and where one registered medical practitioner has given a written opinion that one of the gamete providers, or the woman that's going to be treated, is prematurely infertile or is likely to become prematurely infertile. That is the definition and the standard that must be met by the clinic in order to justify the extension. And as Rachel has already said, that opinion must be provided both in writing and within a given time frame, which is that it has to be on a day within the relevant period. And that's the first 10 years, that first statutory storage period, or within 10 years from the last occasion when an opinion, qualifying opinion was given. For gametes, the same principle applies. It must be for premature infertility or likely to become prematurely infertile. This does not mean age-related infertility. It must be premature infertility. There are incredibly complex transitional provisions which apply to gametes and embryos which were already in storage on the 1st of October 2009 when the current regulations came into force. And different rules apply depending on whether the material that was stored on the 1st of October 2009 was being stored under the initial statutory storage period or was already subject to a qualifying extension under the regulations that were in force at the time they were stored. You'll be pleased to know that I'm not going to talk about this in great detail. It is a little dry, but if you do have specific questions about how the transitional periods apply, we could perhaps talk about it after the event when everyone else has gone home. You still, however, need a medical practitioner's opinion, but this in itself is complicated by the fact that there are different definitions of the relevant period depending on which set of regulations apply. And you may need to look all the way back to the 1991 regulations in relation to the storage of gametes and see how they apply today to determine whether or not you can continue to store or extend storage again. Where you find that you do, in fact, have a problem, where there are missing forms or where forms haven't been completed properly or where there's an absence of an adequate or correct medical practitioner's opinion, it may be possible to go to court to ask a judge to make a declaration to clarify the position and to determine whether or not you can, in fact, either continue to store or use gametes and embryos in treatment. The courts have dealt with a range of different issues relating to missing forms, problems in the completion of forms, the lack of HFEA forms, but some evidence of other decision-making, and also issues relating to patients' human rights. Sarah mentioned at the outset that there have been a range of problems that have gone to court relating to consent, particularly in relation to legal parenthood. And one of the first cases that looked at this was a case about missing form at Barts. And the court, quite simply, was asked to determine whether or not it was most likely that the form had in fact been completed by the patient and then subsequently mislaid. The judge was satisfied that it had been and so made an order accordingly. And so if forms are missing, it may be possible to read in that they were most likely to have been completed. A group of legal parenthood cases were then considered by Sir James Munby, then President of the Family Division, but far more notably a former keynote speaker at Progress's annual conference. And he found that where forms hadn't been correctly completed, they could in fact be corrected by the court and rectified. And subject to the content, if the clinic had its own documentation, internal forms that patients had completed, they could be relied on even if the patients hadn't used HFEA forms. And like the X and Y case, he also found that if forms are missing, the court could make an order that they were most likely to have in fact been completed. So he found a range of different solutions to a range of different problems. That's not to say that all problems can be solved in this way, but in those 7 cases, he found that all of them could in fact be remedied. In relation to human rights, the Human Rights Act requires that courts must, as far as possible, interpret primary and secondary UK legislation so as to comply with convention rights under the European Convention on Human Rights. And this was one of the factors that was taken into account in the court in the case of Beth Warren, who wanted to use her late husband's sperm samples where he had given some consent but not completed a new extension of storage consent using HFEA forms. And the court there used the human rights considerations in relation to his right to respect for his private and family life to allow an extension of storage. And here she is, happily leaving court, having been given the order that she sought, where the court pieced together, if you like, a mosaic of evidence from her late husband's family, and from other sources to satisfy the judge that had he known of all of the options available to him, he would have correctly completed forms to extend his storage. But as I say, it is not the case that this will always be something that can be rectified. It may be that there isn't evidence of that kind that can be pieced together in that way, and it may be that forms, as Sir James Munby said in the Rie case, are so manifestly defective that they can't in fact be rectified even by an imaginative or creative judge. And as Rachel touched on, there are some statutory provisions, like the requirement for the medical practitioner's opinion to be provided in the relevant period, that simply can't be ignored. Now, I'm being shown a sign that says nil point, so I think I need to stop. I'll finish with one point, if I may, which is that I hope the difficulty that I've had in explaining this demonstrates the complexity of the law that relates to storage of gametes and embryos in this area. The fact that it is difficult to explain, to my mind, in this field is an indication of how it needs to be reviewed and reformed. It should not be as complex as it is, and it should not pose the challenges that it poses both for patients and for clinics who are looking to store and use their material. So I will now sit down, but thank you.